Any mention?
Yes, Your Lordship. My Lord, I beg to make a mention of item number 8, as the conducting counsel is disposed, Your Lordship.
Yes, Lordship. No objection, Lordship. 8 and 9 are, my Lord, connected matters.
My Lord.
8 and 9.
9 I am for the petitioner.
In 8 I am for the petitioner.
2 weeks.
2 weeks, Your Lordship.
8, 9, 2 weeks.
Oblige, Your Lordship.
Please, Your Lordship. Your Lordship, I beg to mention item number 15. Lordship, I'm praying for some accommodation in this matter, Your Lordship. Praying that this matter will come up after 2 weeks.
3 weeks.
Item 16, not. I pray for 2 weeks, not. 16. 1-6. Personal difficulty, Lord. Second house.
No
The
objection.
matter has been heard.
No, my
No,
lord.
no. 2 weeks.
2 weeks.
May I please the Lordship. Lordship, hearing item number 13, in that case, Lordship, during the filing of the paper book, we could not annex the copy of the sentence, Lordship. So, I may be permitted to annex the copy of the sentence in this case, Lordship. And moreover, Lordship, in this case, your Lordship was taken the evidence during the trial, Lordship. So, of late we just
13.
yes, Lord, 12 and 13.
I've taken the evidence.
Yes, Lordship. Of late we just
So how will that?
that's
matter?
that's what Lordship just making some.
What can the court do in evidence? Tell me.
No, so,
Can the court impose any decision on the? Maybe if hearing if the court has heard the parties or passed some observation, maybe. Of course, it depends. We have to file a supplementary paper book then.
we can just make some correction, Lordship, in the paper book,
What correction?
or if Lordship allows,
How do you do it?
we'll make supplementary.
You have to tear that paper book.
No, no,
Put it
Lordship,
there.
okay. We'll make a supplementary paper book annexing that one.
You ask her, she knows. She's experienced enough. 1 week.
Oblige.
May I please, Your Lordship? I beg to mention item number 11. I humbly pray for 2 weeks' time, Your Lordship.
No objection, Your Lordship.
3 weeks.
Deeply obliged.
On supplementary list, item number 1.
Yes, ma'am. May it please your Lordship. Lordship, before my friends start, your Lordship, if I may point out, your Lordship. Lordship, kindly have a page 3. Respondent number 4, ex-complainant, your Lordship. This is
Yes.
This is not a POCSO case, your Lordship. Lordship, kindly have a page 15, that is the FIR. This is the FIR under section 104, 109, 118, 191, 161, Red with Arms Act, your Lordship. Then
This is those cases where
Lordship, yes.
number of
Lordship, yes.
cases have come before.
Lordship, yes. Then Lordship, kindly have a para 9 at page 6.
Page 6.
Lordship, yes. Para 9, your Lordship.
Yes.
It appears, your Lordship, that 2 bail applications have been filed, 2 before the learned Chief Judicial Magistrate, 3 before the learned session judge, but this bail application have not been enclosed, Your Lordship. This is in contradiction to the judgment passed by the Honourable Supreme Court. Your Lordship, kindly have this judgment. Lordship, kindly have a para 22.
Mr. Nath, you can withdraw this and file a fresh one.
So it's not maintainable, Your Lordship.
It's not.
Why have you made a complainant party?
No, even Your Lordship, this judgment also, it has been circulated to all the Registrar General of all the High Court.
Yes, yes.
High Court, Your Lordship. So this has to be complied with, Your Lordship.
You have seen para?
Para 22, Your Lordship. If I may point out, if I may read, Your Lordship. Lordship, kindly have para 22 at page 446, Your Lordship. Lordship has gotten.
Yes.
It says like this, Your Lordship. In our opinion, to avoid any confusion in future, it would be appropriate to mandatorily mention in the application filed for grant of bail details and copies of order passed in the earlier bail application filed by the petitioner, which have been already decided. So it has not been done, Lordship. And Lordship, kindly have a para 25 or para 26, Your Lordship. A copy of the order be sent to the Registrar General of all the High Courts to be placed before the Chief Justices for correction of the system wherever required, as this court come across similar issue from different High Courts. So this has to be complied with, Your Lordship.
Mr. Nath, you have this judgment with you?
Lordship, I can.
I'll get the copy, man.
432 para 22. So in view of this, Lordship,
He will withdraw it. Liberty to file fresh.
Lordship.
File it tomorrow morning.
Mr. H.R. Nath, Learned Counsel for the petitioner, has prayed that this petition may be allowed to be withdrawn with liberty to file afresh. Pray aloud. Petition is accordingly disposed of. Dismissed as withdrawn with liberty sought for allowed. I have to go here, paragraph. Mr. PSO for the state respondent.
Item number 2.
Lordship, may I give Your Lordship, this judgment may be brought to the notice of the Registrar General, so that that judgment, Your Lordship.
But whether that would not be for us, it will be for the registry of the Supreme Court to do it. It must have come.
Lordship.
But if you want to check, you can check from the registry.
Lordship, yes.
Or I can cross check.
Lordship.
Mr. Prasad, I'm very sorry, but I have to recuse on this. This matter for any other bench except me.
Item number 3.
May I please,
Mr. Prasad? Call it Prasad. I have not cited any reason. If you want to know reason, you can ask me privately.
Yes. Even the second appeal was listed before this court.
That will
be recused.
may I please, Lordship. Lordship, I am appearing as a legal aid counsel, Lordship. The appellant herein is challenging the order dated 20 October 2022.
It's for admission?
It's for admission hearing.
Admitted.
Lordship, I have also filed an application seeking...
Let the trial court...
We have some objections as well. We have some objection, Your Lordship, because there is, in the petition, there is no records, Your Lordship.
Let the records come.
Without entering... Yes.
Let the records come.
Yes,
the paper book.
Because the court also has to go through the
yes,
record.
Your Lordship.
Yes, sir.
Even for suspension of sentence,
you know,
merits has to be looked
Merits
into.
has to be, yes, Lordship. Obliged, Lordship.
Daily list item number 1.
Lordship, the service report with regard to respondent number 4 and 5 is awaited, Lordship. So once the service is completed, Lordship, I'll place the CD and the status report, Lordship.
Mr. Sheikh Leonard J has submitted that the status report on the service on a notice issued upon respondent 4 and 5 have not yet been could not be filed. As such, it is prayed that some time may be allowed for the same to be filed. Mr.
We have taken these steps.
Connie has prayed for, same as allowed. The interim bail granted will remain in force until further orders. This is matter of 2 weeks.
Obliged.
Item number 2.
I had these are those anticipatory bail applications, where in the CD it had come out, there was some warrant. We have got the certified copies of the.
Your Lordship, if I may interject, can the I'm praying that the matters come at the end of the board. Mrs. NG Shilla is on legs in court number 1.
We'll see. We'll hear what do
The warrant is not there, my lords. Too much has happened. There was indeed a warrant somewhere in 2024. After that, my lords, there was a matter that had gone to the Supreme Court. Supreme Court had that passed certain orders, so that warrant came to an end. So as on today, there is no warrant, my lords. We verified. That's why I wanted to verify from your lordships.
No, but how can you say there's no warrant? Because the warrant has to be, it has to be dealt with.
Well, it was dealt with by the Honorable Supreme Court by granting bail to the petitioners. Thereafter, there was this. Your lordships would recollect the father was arrested.
That has to be acknowledged by the court concerned.
But that's why we took out the certified. My lords, we obtained the certified copy of the entire order sheet.
Okay.
So have you flagged it? We'll just flag it, my lords, for your lordships' kind convenience.
End of the board.
Let it be at the end of the board, my lords. I'll just flag it.
Obliged, Your Lordship.
That Warren, my lords, died a natural death by virtue of that order passed by the Honorable Supreme.
Yes, if that is so, there has to be some indication.
Yes. We'll just point it out.
Obliged, Your Lordship.
And give them a copy.
My lords.
Item number 4.
The LCR was called, not in this matter. For prepare.
Your Lordship, we are filing our written argument in this case. Item number 5 and item number 5 is FA2 and item number.
We are for respondent.
Correspondent number 3.
What about 1 and 2?
In the cross appeal, we are there.
Yes, but respondent 1 and 2 have they filed? Who is appearing?
The government.
Yes, miss. Have you filed yours?
Your Lordship, I believe state has filed, Your Lordship.
They have already filed, Your Lordship, their written argument.
Okay,
Lordship, the appellants have filed their written arguments on the last date. Even the collector has filed, Your Lordship. Only the NHAI was supposed to file it.
Okay, so they have filed. Respondent, Mrs. Then counsel to respondent 3. has submitted that the written argument on behalf of such respondent has been filed. You have to file two sets of.
Okay.
You have file only one. This is only in the cross appeal.
Or this is the main.
What about the main?
Another one.
What about?
I'll be filed during the course of the day. I don't have a copy.
You are there in the
item 10 and there, Lordship.
Item 14
on the.
This is not. See, your thing is not clear. You have mentioned FA2. Then here you said.
You're not mentioning 10.
No.
Here you said cross appeal.
14.
I don't know.
Yours 14, sir. I'll file on the next.
This is not clear. See, look at. You should make it clear.
Yes, Your Honor.
You're mentioning cross appeal. This is not the cross appeal.
Yes, Your Honor.
Cross appeal is the other case, isn't it?
Okay, I'll recorrect it.
Be careful, so, because for you it's okay. You just dump it.
Yes.
But I have to do the sorting out.
Yes, Your Honor.
I know.
Lordship may give a short date as the hearing in this case concluded in March, Your Lordship.
1 week. Yes. On pre-made by 2. Respondent 3. This is matter 2. 1 week. Do it properly.
Much obliged, Lordship.
Item number 6.
Yeah, please. Lordship, this matter pertaining to the alleged encounter by the police. The deceased is the brother of the petitioner. My lord, here the incident occurred on 13 August 2021, whereby the police has conducted a raid to arrest the deceased. In that incident, Your Lordship, the deceased was shot and succumbed to his injuries. My lord, the deceased was the former member of the band.
What is your prayer here?
My lord?
What is your prayer here?
To hand over the investigation of the case to the CBI.
You are challenging the findings of the commission. Commission of
I'm not
inquiry?
challenging the finding of the commission. In fact, I'm relying on the finding of the commission.
Or you're relying?
Yes, ma'am.
If you're relying, then what is the findings of the
Findings, Lordship, can come to in fact, Your Lordship, the commission has been directed to cause inquiry into 3 aspects. One is for inquiry into the facts and circumstances leading to the police action on 13 August 2021, resulting in the death of the late so-and-so, former general so-and-so. Number 2 is for giving a fact-finding report as to the culpability or otherwise of the police action resulting in the death of the deceased so-and-so. So, my lord, the first part of the reference was not challenged by us because we don't know the criminal activity of the deceased. However, we are concerned only with the reference number 2, that is the for a fact-finding report as to the culpability of the state policeman. So, my lord, page 37 is the finding of the commission, and the operation part, para 31. May I read?
Mr. Kumar,
Yes, my lord.
any challenge on maintainability?
Yes, my lord. We have raised number of grounds, but so far as maintainability of writ petition is concerned, my lord, they can file the writ petition. That your lordship has the jurisdiction. So on that issue is not there. But the so far as the inquiry commission report is concerned, my lord, it is under the judicial inquiry commission report, my lord. And the report, my friend is saying that this is the basis for seeking initiation of CBI investigation and all, my lord. The law on this point is settled that that first report is in favor of the state government, not for and against the. There are certain suggestions which have been made by in the inquiry report to the government that in future, whenever you have to undertake these kind of operations, you should undertake these kind of safeguards. Those suggestions have been noted, and as per the Inquiry Commission Act, my lord, those reports are required to be placed in the assembly. That has also been placed. Probably here, action taken report we have also placed, my lord. Otherwise, I will place that action taken report, my lord, on the Inquiry Commission report, and then thereafter you.
Why have you not done so in your affidavit?
Yes, my lord, because this is the action status report. We have action taken report is placed in the assembly, because initially, if your lordship will see, issue was the orders. If your lordship will see the previous orders also.
See, now you're referring to the action taken report.
Yes, my lord.
If you place the same before this court, then you have to do it by way of an affidavit, or you
Yes,
should have
my
done
lord.
it earlier so that they can finally rejoin the.
In fact, my lord, we have placed the proceedings of the assembly, my lord.
By affidavit.
Affidavit.
By affidavit, yes. The affidavit.
So the only query or concern of this court is whether this court can see in which jurisdiction under 226 can sit over any finding of a inquiry.
Yes, it cannot, my lord. That is my humble submission. That is my legal submission also, my lord. And for that I can place. I'll place one.
There may be some conflict of jurisdiction.
What I will place one small applications raising this ground specifically, so that my friends should be aware that.
Or whether you have recourse
Well,
elsewhere.
there
It's
are
not that
other
you see,
grounds
it's not that you are without remedy.
Yes,
You
ma'am.
may have a remedy, but it may not be here. It may be elsewhere.
There are
Before
other
the
grounds
learned
also.
magistrate, before the.
Whatever, we don't
yes.
know. We don't know.
So I'll file, my lord, a short objection on this ground. Kindly give me time, my lord. I will do that, my lord. My objection is on this
Because
issue.
first the legal basis has to be established.
Yes, certainly. Lots of
Once that
lots,
is there, if the court is convinced that yes, it does have the jurisdiction, then
yes, my lord. Then
matter
your
of
lordship
facts
may.
or matter or merits will be looked into.
Yes,
My lord, in fact, I have two citations, my lord, regarding the jurisdiction under 226.
Exactly.
So, my lord, I think I have to establish a prima facie case.
Exactly.
Yes, my lord. But I will file, my lord. Whether inquiry commission report they can be relied. I have got some authorities with me, but that was not the issue. That is why it did not transpire in my mind, my lord. That
that has not gone. That has not gone in the pleadings.
It has, my lord. We have said that inquiry has been conducted, and if your lordship will see my counter affidavit, where I have taken the ground specifically, my lord. If your lordship will kindly have my counter affidavit, my lord. Paragraph 25 at page 10, my lord. And before that, my lord, I have called out the finding of the inquiry commission in paragraph 22, my lord. The important conclusions, paragraph 22 at page 7, my lord. Your lordship has the page 7, paragraph 22, my lord.
Yes.
The important conclusion of the report of the commission on the issue number 1, circumstances leading to the police action on 13th August 2021, resulting in the death of late so-and-so, can be summarized as under. Commission held that decision to arrest late so-and-so by the police was fully justified. This is the first finding I have given. The stand of the government is fully vindicated by the finding of the inquiry commission report. Commission has evaluated the evidence and came to the arrest of the late Chesterfield was fully justified. Commission has also affirmed the fact that decision to arrest was not a knee-jerk, sudden, but prolonged and professional investigation of criminal activities like IED explosion. Commission has also recorded that the fact that even the family members of deceased also did not dispute the fact investigation was proper, paragraph 19. That is, submitted Commission inquiry on operational issue has made certain observations. Commission of inquiry in paragraph 32 has noted that operation was well laid down plan, but Commission also held that it was executed poorly. However, it is humbly submitted the Commission has not held that police or member of tactical team capable of on any manner. Certain suggestions have been given on the issue of similar operation in future. Commission of inquiry, after 8 months of detailed inquiry, after examining the police and public witnesses, submitted report on 19th May 2022. And then, my lord, after recommendations, my lord, paragraph 25, my lord, kindly have paragraph 25. These recommendations are only on the operational parts of the police action. In this regard, reference may also be made to the Honorable Supreme Court judgment in Ramkrishna Dalmia versus S.R. Tendulkar 1959. Commission has no power since passing order which can be enforced properio vigere. A clear distinction must be on the authorities be drawn between decision with itself no force and no penal action, my lord. And then, my lord, kindly see 26 after I have quoted the relevant provisions of the Commission of Inquiry Act in page 20, paragraph 26. In 27, my lord, I refer paragraph 27 in various high courts, my lord, paragraph 27. The provisions have been held by various high court to be a directory provision, and in this regard, reference may be had to Narayan Rao versus State of AP 1986 SSC online AP 116. This brings to the question whether subsection 4 of section 3 is mandatory or directory. On a consideration of argument pressed upon us by both sides, we are inclined to hold that the provision is not mandatory. There is no other provision of the Act which provides for consequences that flow from non-observation requirement. Shankar Mohanty versus State of Odisha, my lord. In view of the foregoing, we are also view no direction by writ mandamus can be sued to opposite party number 1 for laying reports of the Commission of Inquiry before the legislature of so and so. Now, my lord, in common cause, the Supreme Court has laid down inter the other direction, namely direction to CBI to investigate any other offence, is wholly erroneous and cannot be sustained. Obviously, direction for investigation can be given only if offence is prima facie found to have been committed or person's involvement is prima facie established, but direction to CBI to investigate whether any person has committed an offence or not cannot be legally given. Such a direction would be contrary to concept of philosophy of life and liberty guaranteed to person under Article 21 of the Constitution. This direction is complete negation of various decisions of this court, in which the concept of life has been explained in manner which has infused life into the letters of Article 21. It is submitted that the Honorable Supreme Court in Sujata Ravi Kiran versus State of Kerala 2016 7 SCC 597, where the Honorable Court held the extraordinary power of the Constitutional Court.
Mr. if you feel that you have dealt with the matter, extensively in your counter,
yes, my lord, we have raised 2 points, my lord, in my counter affidavit. One point which I have raised, my lord, is this, that they are relying on the findings of Inquiry Commission report. My submission to what is coming from my learned friend's argument is that Commission of Inquiry has held in my favor on fact, my lord. That is on fact my submission. Second submission which I have made, my lord, is that in law, you cannot rely on the findings of Commission of Inquiry to say that it has held in one way or the other. At best, it will have persuasive value for the court. Your Lordship can take note of the and persuasive value from both sides, because some findings are in my favor, because my case is finding is in my favor. My learned friend's case is that some observations are in his favor. Your Lordship will ultimately decide. Even assuming after argument of both sides, your Lordship goes through and then your Lordship may take a persuasive view of the matter, either in my favor or in favor of my learned friend. This is all we can rely so far as Commission of Inquiry is concerned. So far as the other material is concerned, it is for my learned friend to establish that there is a prima facie case, one, not prima facie, ex post case, and second, then my friend has to show that the investigation which has been carried out, has taken place, is not in accordance with law. Then my friend can invoke the extraordinary jurisdiction of this Honorable Court, whether after 5-6 years, 21, then because the step number 1, inquiry has been conducted by a retired judge of this Honorable Court. All witnesses they have produced from their side, our side, the inquiry has gone into the facts, given some finding. Those findings are in my favor, saying that everything was done. There was some omissions and negligence in not proper conducting. Those are standard operating procedure.
Have you filed a copy of the inquiry
Yes,
report?
inquiry report is on record.
It's on record.
So, is on record. So your lordship will be required to go through the inquiry report minutely on fact. Then we'll assist your lordship on law. We'll assist your lordship on all these aspects. But so far as maintainability is concerned, which was a question which came from your lordship, the Honorable Supreme Court has said that writ is maintainable. My lord, Constitution bench has held in state of. On that, I do not. Writ is maintainable, but whether your lordship would exercise the jurisdiction or not, that is a second issue.
Once we decided on that, you see, the rest would depend on the.
Yes, yes, madam. To that extent, I do not dispute the filing of the writ petition. But my submission would be it is abuse of process of law. Those submissions I reserve, my lord. So, my lord, we will, your lordship, because now all those issues are being raised. I have prepared the compilation of judgment also on this issue, my lord. If I can give it to my friend in advance, he can go through and can place it also, my lord, so that we can have it, because it will require lengthy hearing on all aspects of the matter, my lord. This will be.
He's prepared.
He's prepared always. I have seen my friend is always ready. I have no issue. My friend can argue. I can't. I have no issue, my lord. I will. I may take the.
Also prepare
yes, I may respond on next date of hearing. Yes, my friend is ready. He can continue his argument.
There's some dates and events and all those things. Have you prepared that?
I'll prepare that. As of now, I don't have.
Filed? You have not.
No.
We'll file a list of dates and events, my lord. We'll do that both sides, and list of judgments relied by us both sides, my lord. We'll do that, my lord, so that we can assist your lordship on this matter.
2 weeks then?
Yes, ma'am. 2 weeks.
I'll prepare with parties. This is matter 2 weeks.
It will be.
Item number 7.
Obliged.
Yes.
May it please your lordship, on last date, my lord has asked me one particular question, that when did I file the application under Order 7 Rule 11. So my lord, I have prepared the list of dates, my lord, regarding the applications right from the suit when it was filed till the appeal, my lord. So, my lord, here the challenge is the order dated 28/11/2024, my lord. My lord, the operative part of the order is at page 50. Page 50, my lord. So may I read, my lord, the operative part of the order?
Yes. Please.
I am hereby of the opinion that the money transaction should not be considered as the time for counting the period of limitation, but the course of action has to be taken under consideration. This is one part, my lord. And the second part is that further, as per Chapter 4, Civil Justice Rule 34 of the Law of Administrative of Justice in Meghalaya reads as under, except in so far as provided by these rules, the Indian Limitation Act 1908, Act 9 of 1908 shall not apply to suits in which either or both the parties are member of scheduled tribes or tribes specified in Item 1 and Part 1 Assam of the Schedule of the Constitution of India. So this is the two part wherein the appellate court has said that the Limitation Act is not applicable between the tribes, and also the first part wherein the appellate court has stated that in money cases, only what has to be considered is only the course of action, but not the time for counting the period. My lord, that is the two aspects that I'm here before your lordship. So my lord, the plain is from page, the plain filed by the respondent, my lord, is at page 52, my lord, till page 111, my lord, sorry.
Yes.
So, my lord, I'll take my lord to the relevant part of the plain, my lord. Here the crux of the matter is that, my lord, here the respondent, her father, my lord, the deceased father had filed a suit for recovery of money in the year 2020, my lord, numbered as money suit number 1 of 2020, and the money for recovery was 94,85,000, my lord. And my lord, at that point of time when they filed, my lord, we have filed with this, my lord, there was also an application under order 39 1 and 2 for the injunction, my lord. That also was granted. We had filed the reply for that application. We had filed a show cause. We had filed the written statement also, my lord. And on reading the plain, my lord, we have found that the plain is barred by Limitation Act, my lord. And then further, we have filed an application under Order 7, Rule 11. So, my lord, I would like to take my lordships to para number 4 at page 54, my lord, of the plain.
Yes.
The plaintiff was most writtenly connected and deceptively persuaded by the defendant as to the purported success of her supported business deals in the year 2014. The plaintiff have even availed a loan of amount of 49 lakhs from the State Bank of India Garikhana branch in order to finance the defendant for the purchase of a plot of land located at Lapalang Dong Parmao, Lapalang village under Millennium's Aimship, measuring an area about 58,638 square feet, and which land was to be sold off in plots, and the amount of 49 lakhs rupees only, as also half the profit occurring from the said sale was to be paid out to the plaintiff by the defendant. My lord, this is the schedule of the property. Coming to para number 5, my lord, that the plaintiff begs to present here under the list of various financial transactions, including those refer in clearance statement of the plaintiff account advanced by the plaintiff to the defendant at various dates. 0304-2014 check number so and so 9 lakhs, 0304-2014 check number so and so 9 lakhs, 0304 check number so and so 7 lakhs, 0704 check number so and so 5 lakhs. And my lord, on the 10/6/2016 via transfer 25,000, 15/09/2050 via transfer 10,000, and 05/10/2015 payment made for the excise license on behalf of Sminty so and so 50,000, my lord. So my lord, kindly see in 2015, my lord, as per stated in para number 4 for the purchase of a plot of land, but there are several kind of transaction, and the transaction which is given below is for the other purposes, my lord. And secondly, my lord, I would like to read the para below, my lord. It is apt to state that at the request of the defendant, the plaintiff had, prior to the transferring the aforesaid amount to the defendant, had given to the defendant by cash a sum of rupees 19 lakhs, which the defendant had stated was that the amount required for payment on the earnest money security in respect of the plot of land at Lapalang village. Thus, the cumulative amount taken by the defendant from the plaintiff stands 49 lakhs 85,000. Further, my lord, I'd like to read para number 6, that the plaintiff begs to submit that as any normal person who invests on business, the plaintiff also having trusted the defendant, who all this while projected herself to be an active businesswoman involved in real estate dealings. With this big an investment as reflected herein above, was hopeful that the financial assistance given to the defendant would be repaid at the earliest. That the plaintiff begs to submit that in order to further win the plaintiff's trust, the defendant even asked the plaintiff to accompany her when the full payment in respect of the aforesaid land was made. However, the plaintiff then complete trust in the defendant and as such declined to the same. It is apt to state herein that all the above transaction has been done by the plaintiff having full faith and trust on the defendant, and the defendant being an elderly lady, the plaintiff was under the impression that a lady such as the defendant would hold her word with regards to the repayment of financial assistance advanced by the plaintiff to her, the defendant. That even after many months had passed, the plaintiff did not receive any word from the defendant about the repayment to be made to the plaintiff, and being wary of the defendant's silence on the same, the plaintiff called the defendant to inquire the same. It is pertinent to mention that on every such occasion, the defendant would give one excuse to another, clubbed with various unfulfilled promises of returning the financial assistance at the earliest, and against which the plaintiff believed the excuses given to be genuine most gulpily accepted. That the plaintiff begged to submit that he, the plaintiff, have been informed by his well-wishers that the defendant intend to dispose of the aforesaid land, and after which he, the plaintiff, called the defendant to ask about the repayment of his money. However, on this occasion, the defendant threatened him that she will sue him for harassment, and she even refused to acknowledge that she, the defendant, owed the plaintiff any amount. That the plaintiff, when realized the defendant has no intention of paying any repayment whatsoever to the plaintiff, and in fact intend to defraud the plaintiff of his right to claim to the amount given to the defendant for the purchase of the aforesaid land by disposing the aforesaid land, that till date the defendant has failed to make the payment towards repayment of the financial assistance given to her by the plaintiff. That the said failure of the defendant to repay the amount taken by her from the plaintiff has caused great inconvenience and financial hardships to the plaintiff. That the plaintiff had given the said amount of money to the defendant in good faith and with the honest belief that the money would be returned and repaid as promised. So, my lord, this is the plain, my lord, this is the facts of the case. And my lord, the WS starts from page 103 to 111. And further, my lord, the application under Order 7, Rule 11 is from page 124 to page 130. The application, yes, my lord, is from page 124 to 130, my lord. And further, my lord, the learned when we had filed the application under Order 7, Rule 11, before the presiding officer, my lord, it was on the 2nd/09/2020, my lord. They, while deciding this application, they have touched our written statement. After reading the order, because there is a ruling, my lord, that while deciding the 711 application, only the plain has to be read as a whole. They cannot touch the written statement. So we have challenged that order before the appellate court, Judge District Council, my lord. Therefore, the Judge District Council had stayed the proceeding of the trial court, my lord, and called for the records. And we have filed the appeal, my lord. The appeal starts from page 156. 156 to page number 170, my lord. So, my lord, my grievance is, my lord, is that firstly, my lord, the appellate court has stated that the Limitation Act is not applicable in the state of Meghalaya, which is against the full bench judgment of this honorable court, my lord, wherein the full bench, my lord, has clearly stated that even if the petitioner, the parties to the suit are tribal in nature, the Limitation Act will be applicable, my lord. I have served, my lord, that judgment is with my lordship. And secondly, my lord, wherein coming back to the order, my lord. Wherein the learned appellate court has stated that in money transaction, only the cause of action has to be seen, which the appellate court has directly stated that, my lord, that cause of action has to be seen is that the appellate court is saying that the in Limitation Act only Article 113 is applicable. So, my lord, may I take your lordships to the Limitation Act? My lord, kindly come to Article 113 of the Limitation Act.
Yes.
Article 113, my lord.
Yes.
Part 10. May I read,
Yes,
my
yes,
lord?
please.
Suits for which there is no prescribed period, my lord. Article 113. Any suit for which no period of limitation is provided elsewhere in this schedule. The period is 3 years when the right of sue accrues. So, my lord, the appellate court is saying only Article 113. Now, my lord, Article 113 is a residuary clause. So, 113, my lord, if we read again, my lord, here it is written that any suit for which no period of limitation is provided elsewhere in the schedule. So, my lord, if there is no period of limitation provided from Article 1 to Article 112, my lord, then Article 113 will be applied. So, my lord, in my case, my lord, Article 19 and 20 is applicable. My lord, kindly come to Article 19 and 20.
Yes.
Article 19, my lord. Description of suit for money payable for money lent. The period of limitation is 3 years. My lord, time from which the period begins to run when the loan is made.
Yes.
And further, my lord, kindly come to Article 20, my lord.
Yes.
Like suits when the lender has given a check for the money. 3 years when the check is paid.
Yes.
So, my lord, the learned appellate court, by stating that only Article 113 will be applicable, then what will happen to the rest of the articles which is described in the schedule? That also has to be seen, my lord, because the rest, especially where Article 19, 20 and 21, which deals specifically with in cases of money, my lord, that has to be seen by the appellate court, because when the appellate court has not said that in this case, my lord, said that in money cases, so in all money cases only Article 113 will be applicable, which is absolutely wrong. And my lord, because this 113 article, my lord, is an article of residuary clause. If there is no article provided elsewhere for a claim or a limitation period, then Article 113 will come into picture, because it is specifically mentioned here.
So, according to you, because there is Article 19 and 20, so Article 113 will not apply.
No, my lord, because Article 113 is a residuary clause. My lord, Article 113 is an article when there is no article, when there is no time period provided elsewhere there, my lord, because it's specifically mentioned here. Then, my lord, Article 113 will apply. Otherwise, Article 19 and 20 will be applicable. So, Article 20, like suits when the lender has given a check. My lord, kindly come to my plane, my lord. Kindly come to para number 5, sorry, of the plane, my lord, which is at page
think you have read that out.
My lord, I want to show, my lord, wherein they have given the dates when the check is paid, my lord. That is on 03/04/2014, my lord. The amount is 9 lakhs rupees, my lord. The limitation is already over in the year 2017. And my lord, likewise, 14 again 2017, my lord. So 2016, it's 2018, the limitation period is already over. And my lord, what was the plaintiff doing for 6 years, my lord? And section 3 of the Limitation Act, my lord, kindly come to section 3 of the Limitation Act, my lord. May I read, my lord? Part 2.
Yes.
Subject to the provision contained in section 4(2)(24), inclusive, every suit instituted, appeal preferred, and application made after the prescribed period shall be dismissed, although the limitation has not been set up as a defense. My lord, now this section says that any suit which is filed beyond the period of limitation is required to be dismissed. So my lord, and my case strictly fall under Article 19 and 20 of the Limitation Act. And further, my lord, if we come to para number 5 itself, further, the plaintiff herein has stated about 90 lakhs that he has given. My lord, there is no date when it has been given, how it has been given. And further, my lord, there is, in the entire plain which I read out to my lord will find there is no date as to when I was required to repay the loan. And my lord, the dates are very important, my lord. And when he has raised the demand, the date has not been given. He has only stated in para number 9, my lord, that I refuse. But the date of refusal has also been there. The date of demand also required to be annexed in the plea.
Why are you going to all those facts? See, because that, as far as this court is concerned, that is immaterial. The court will not go into the merits. Now we are here only on issue of jurisdiction. So you just apprise this court of the impugned order, why it's not sustainable.
My lord, my only humble submission is that, my lord, when there is a full bench judgment, that Limitation Act is applicable in the state of Meghalaya, my lord. So the learned appellate court, by saying that the Limitation Act is not applicable, is wrong, my lord.
What is the citation of that case?
It's Shella Action Committee, my lord.
Has it been reported?
My lord, it's MC review petition number.
Must have been reported. SCC online or?
My lord, I have downloaded from the Meghalaya High Court website itself, my lord, the judgment.
You have given copy of it?
Yes, it's there, my lord, I have given.
Shella Action Committee?
Shella Action Committee, Rally of Shella, Village Native versus the State of Meghalaya and others. Date of order is 12 April 2017. 12 April 2017.
Relevant para?
Relevant para is last page, my lord. Conclusion part. The relevant para is at para number 1, the Limitation Act applies to the entire state of Meghalaya, including the tribal areas of autonomous district councils and regions. My lord, I have given the copy of the judgment to my lords. And yes, my lord, this judgment is reported.
Conclusion?
Yes, my lord. Conclusion part. And my lord, the question which has arisen there, it's at the first page, the preliminary part, my lord, and further.
Yes.
And my lord, my further submission is that, my lord, when the appellate court, my lord, had made an observation that only Article 113 is applicable, my lord, that is not acceptable. Because, my lord, the Article 113 is again the residuary clause, my lord. When the other articles are provided elsewhere in the Limitation Act, my lord, especially the case like mine, wherein Article 19 and 20 is applicable, my lord, so that order cannot be sustained, my lord. And wherein the Limitation Act provided, my lord, whereas it's purely applicable in the state of Meghalaya, my lord. So this impugned order should be quashed and set aside, my lord.
Yes. May it please your lordship. My lord, Order 7, Rule 11 application. My lord, this is purely a question of law. This is purely a question of law. Therefore, my lord, first, what was their contention, my lord? Their contention of orders, page 127 is their application of Order 7, Rule 11, my lord. At paragraph 2 itself, they've said that the present application, my lord, has got page 124. That is their application, my lord. Because I will address only on question of law. My friend has gone into the merits of this case, my lord, which doesn't warrant. If that is her stand, then this is a fit case to go and trial. Because then this court will not go into the disputed questions of fact. It is a subject matter of trial. So therefore, I'll try to address only on the question of law, my lord.
Yes.
So, my lord, their application at page 124, Annexure 10, paragraph 2, they said that by the present application, the applicant craves leaves of this honorable court to reject the present suit under Order 7, Rule 11, A and D, as there is no cause of action lies. No cause of action lies. Now, my lord will see Order 7, Rule 11, A.
You're reading para 10?
No, my lord. Page 124, paragraph 2, my lord. Paragraph 2.
Paragraph 2.
2, my lord. That's their application, my lord. That's the application, the grounds why my suit should have been rejected, my lord.
Yes.
So, the first contention was that there was no cause of action. Therefore, my suit has to be rejected. Rightly so, because Order 7, Rule 11, Clause A says that, my lord, I'll just read, where it does not disclose a cause of action. It says, where it does not disclose a cause of action, then my suit deserves to be rejected. Now, my lord, having said that, I will take my lord to page 171. 171, my lord. This is the order of the learned presiding officer. Can we look at the observations, my lord, of the learned presiding officer? Here, my lord, rightly the presiding officer, so also the appellant court, my lord, has held that the cause of action is there, and they said that it's not a mere transaction. It's not a mere transaction. It is a cause of action. My lord, just give a submission. My lord, page 171. Now, my lord will see page 171.
This is the order.
Yes, this is the order, my lord. We'll have to look at this order, my lord, because this is a detailed order. The reason given, the contention raised by the petitioner here, and also the contention raised by the respondents here, and cumulatively how the observation has come to and hold that there is a cause of action. My lord will see. May I be part? This will take little time, but this is important to read, my lord. So may I take the liberty to read from page 172, my lord. Page 172. The instant case is put up today for orders. The defendant filed an application under Order 7, Rule 11, A and D, CPC for rejection of the plaintiff. The learned counsel for the defendant stated that the plaintiff filed the instant suit in the year 2020 is passed by limitation. The recovery of money paid through checks in the year 2014 was required to be filed in the year 2017.
Similarly, recovery of money paid through check is the subsequent years was required to be filed within the time, but this suit has been filed in the year 2020, which is barred by limitation. The plaintiff has given the loan amount before 03/04/2014, that is the date when the first check was given. Hence, 3 years period from the date when the loan is made has already expired long time before. Furthermore, there is no pleading with specific dates and time regarding acknowledgement any liability by the defendant. There is no written agreement and pleadings in the plaintiff's suit which manifest when the money has to be returned. That the money has been paid by check and cash, the period mentioned under Article 19 and 20 of the Schedule to the Limitation Act 6 are squarely applicable in this case. Limitation will be 3 years from the date when the loan is made. The present suit is hopelessly barred by limitation. Another point raised by the defendant is that there is no cause of action as there is no agreement placed on record by which the plaintiff had given money to the defendant. The avertment in the plaint that the cause of action arose December 2020 is illusory. Lastly, the defendant contended that the suit of the plaintiff is barred by Benami Property Transaction Act of 1988. The learned counsel for the defendant relied their submissions on the following citations. So and so, the citations, my lord, these are the citations, and then it is manifest that the suit is barred by limitation. Then the honorable courts are required to dismiss such suit even the limitation is not taken as a defense by the defendant. Recently also, the Honorable Supreme Court in the case of Dahiban versus so and so has specifically mentioned that the provisions of Order 7 Rule 11 CPC are mandatory in nature and the courts are duty bound to dismiss the suit appeal application if any of the provisions mentioned in Order 7 Rule 11 violated by the plaintiff. The learned counsel for the defendant prayed that considering all the settled law and limitation period applicable in the present case, the suit is liable to be rejected under Orders 7 Rule 11 A and D CPC. The learned counsel for the plaintiff opposite filed show cause and also submitted before me that he is relying on this show cause for his argument. The learned counsel for the plaintiff summarized the core contention of the applicant as follows. On the ground that the suit does not disclose the cause of action, on the grounds of bar by limitation, grounds of suit is undervalued, the plaintiff first and foremost stated that the provisions of Order 7 Rule 11 CPC are guided only in the spirit and not in the letter as led under paragraph 5 of the 6th schedule to the Constitution of India. The plaintiff admitted there was no specific repayment date for the loan, that it is averred that the subject matter is for recovery of huge sum of money given at various intervals to the applicant. The defendant and it is only when the applicant defendant refused to acknowledge repayment of the financial assistance on December 2019 that there arose a course of action leading to approach this court for relief. The plaintiff relied on the judgment passed by the Honorable Court of Delhi in Satish Kumar versus so and so. It was held the limitation to recover loan, the course of action will arise on the date when the loan is not repaid. That is not from the date of grant of the loan, but after 1 year or 2 years or 3 years of grant of loan, when cause of action will arise to file the suit for recovery of amount. Further, another is that the Honorable Apex Court in Shakti Bok versus so and so, in Ashok Kumar versus Qatar Singh, that when the cause of action arises, then the limitation period of 3 years starts. 3 years starts from the loan to be repayable. The plaintiff opposite stated that in his show cause that it was the applicant defendant who approached the plaintiff that she would share a portion of the profits accruing from the supposed sale of the loan purchased by her own. As such, there is no question of any Benami transaction. Furthermore, in deciding application under Order 7 Rule 11 CPC, it is tried and settled law that the that the Honorable Court are not bound to look into the averment and contentions made in the written statement, and to which the humble applicant herself has successfully clarified and relied on paragraph 3 of her application. The plaintiff opposite party prayed to admit the show cause and dismiss the instant application filed in the defendant. Now, my lord, this is the observation. I have perused the instant application along with the show cause. On perusal, the main contention of the defendant is that there is no pleading with specific dates and time with regard to the transaction with the plaintiff or acknowledgement of any liability by the defendant. There is no written agreement and pleadings in the suit which manifest when the money has to be returned. That the period mentioned under Article 19 and 20 of the schedule to the limitation 90s are applicable in this case. Hence, the limitation will be 3 years from the date when the loan is made, check is made. Furthermore, there is no cause of action. After careful perusal of the citations placed on record, it is clear that suits for recovery of loan granted will not be governed by Article 113 of the Limitation Act, which stated that a suit has to be filed within 3 years from arising the cause of action. In this instant case by the plaintiff, there were several financial transactions between the plaintiff and the defendant at various dates since the year 2014 till 2016. But there was no repayment for the defendant, and subsequently, the cause of action arose in the month of December 2019 when the defendant refused to acknowledge that she had taken financial help from the plaintiff. It is therefore clearly seen that there is a cause of action against the defendant, as a plaintiff has transferred money in favor of the defendant and rendered financial assistance. In paragraph 5 of the written statement, the defendant stated there was an agreement that the plaintiff had also taken loan from the defendant, where the agreement was given back in good faith. Thus, these counter allegations are to be proved by evidence. In view of the above, I find that there is a cause of action, and it is within the limitation period, as the last financial transaction between the plaintiff and the defendant was on 10/06/2016. In the light of the above, Order 7 Rule 11 is not attracted and the instant application is dismissed. The suit is proceeded accordingly. So, my lord, what the court said is very clear, my lord. And citing few citations which is mentioned here, my lord. It is not merely because it is not admittedly, my lord, what the party says that there is no agreement for the time period when I am supposed to do. Purportedly, this money was given for investment in certain properties. This is what is the admitted position of facts. But now, only when you decline to acknowledge the money that was already given to you, which they have also read it to my lord, the various transactions and cash of 50,000, so on and so forth. Only when you fail to acknowledge, I had to knock the door of the court. And the court says, yes, it is the cause of action the day when you declined. I assert something and you declined. That is what we call a cause of action to proceed civil, whatever remedies, legal remedies. This is exactly what the court is saying. Therefore, you cannot beat around the bush. Where now another point is, you are saying that this order is barred, it is bad in law. Why? Because why did you touch my written statement? You should have looked at my. The question comes that, is there an absolutely bar? Legally absolutely bar? No, it's not bar. Written statements are irrelevant when you are deciding Order 7 Rule 11. You have to just see from the plain reading of and the documents of your plaint. But when the court notices something which is admitted, you cannot close your eyes, because there is no statutory bar. There is no absolute bar. You can touch to that extent. So therefore, by saying, and what the court is touching is also their own admission. The court is only looking at their own admission. So by saying that, just to come to a proper adjudication. That much the court was right in doing so. So therefore, here, my lord, this is the first instance where the court has not made this. This is the presiding officer who has rightly dismissed their application, because now my lord has seen it. Of course, it has not to be touched into the merit of the case, but my friend has read out to my lord the facts of the case and where they have admitted. And even in while arguing the applications of Order 7, Rule 11 also, they again and again repeatedly admits that the money was given to me, the money was transferred to me. On these admitted facts, my lord, can I be shunted out on technical grounds, even assuming that there was a technical ground? Once you admitted something, and that's on record. The court has their own submissions. They said, no, I have taken the money, but you should have come on such and such date. Sorry, you did not come on time. That's why now I'm not going to give you back. You go to the court. No court can damage me. This is the attitude that they're showing. So, one hand you are saying that I've taken the money, yes, but another one you are challenging me. Okay, it's limitation. You are barred. You are hopeless now. I can do whatever I want. That is the attitude that they're showing. Admission every part. And the court has rightly said, now you cannot run around the integrities or the legalities of, you cannot hide on law. Now, what they challenged, rightly they said they challenged. And then the appeal, kindly look at the appeal also. So therefore, the order of the appellate court, the order of the appellate court is at page what was page?
Page 50.
Page 50. Okay. My lord, to come to page 50, the order of the appellate court. Page 25, my lord, page 25. Now, what did the appellate court did, my lord? Page 25. May I take to page 25, my lord?
Yes.
Well, it's little a lengthy judgment, but kindly bear with me because this is important, my lord. Because they are challenging the legalities of this order, therefore this needs to be read out, my lord. Judgment and order, my lord. Page 25. The instant appeal preferred by the appellant under Article 28 and 29 of the United Khasi Jantia, it is an appeal against the impugned judgment, money, suit number so and so, grounds, my lord. So the grounds, my lord, will not go into, because this is just the reiteration of the grounds that have taken. They've just copy paste whatever they have said, my lord.
What, go to the operative portion only?
Yes, my lord. My lord, page 49 onwards, my lord. Page 48, my lord. Page 48. Perused, my lord, page 48.
Yes.
Now, perused the written argument, my lord has got page 48.
Yes, yes.
Perused the written argument of the learned counsel for both the parties. Perused also the memorandum of appeal along with the materials available in money suit number 1 of 2020. Upon proper perusal of the same, it is found that the appellant is contended that the suit is barred by limitation. The appellant is further contended that the last financial transaction was on 10/6/26, 2016, and the period of limitation and on 10/6/2019, whereas the suit was filed in February 2020, which is already outside the period of limitation. The learned counsel for the respondent, on the other hand, contended that the cause of action arose in the month of December 2019, when the appellant intends to dispose of the land property purchased by the appellant based on the loan financial assistance provided by the respondent. However, when the respondent approached the appellant for repayment the money, the appellant on the other hand refused to acknowledge that she owed him any amount. Upon proper evaluation of the contention of the learned counsel for both the parties and in comparison with the materials available in records, I am of the opinion that the alleged transaction of money between the appellant and the deceased father of the respondent shall have to be proved through evidence. However, as the main point contention of the learned counsel for the appellant challenging the suit is based on limitation, I am hereby of the opinion that the money transaction should not be considered as a time for counting the period of limitation, but the course of action has to be taken into consideration. Furthermore, as per Chapter 5 Civil Justice Rules, except in so far as provided by the rules, the Indian limitation shall not apply to the suits in which either of both parties are member of the scheduled tribes of the states specified in item so and so. In view of the above transactions, I am hereby satisfied that the impugned order dated 27 October passed by the presiding officer in money suit does not suffer from any irregularities and the same does not require any interference by this honorable court. My lord, here we are, the review petitioner, my lord, is before this honorable court challenging a concurrent finding of two courts below. Concurrent finding of court
My lord, with that aspect, my lord, I'm so sorry, my lord. I am here before your lordship. As per, I am challenging the impugned order dated 24/11/2000. I am challenging the impugned order dated 28/11/2024, my lord. I am not challenging before your lordship the order which is passed by the presiding officer to which I went to the appellate court, my lord. I want to clarify because my lord, my learned senior is saying that I am challenging the concurrent finding, the two concurrent finding.
You can reply. He has not finished.
Yes, my lord.
Yes, my lord. So, my lord, the presiding officer's order is a continuation in the appeal also, my lord, because that's the first instance. So it has to stand all the way. Either it has to fall or it has to stand all the way. Therefore, that order is very important. So whether you say correctly that you are challenging or not doesn't matter, but that's what it is. So, Your Honor, now, my lord, Article 113 of the Limitation Act, as my friend says, is a residuary clause, applies where no specific period is prescribed. And the course of action accrues. When the course of action accrues, my lord, because here the court was of the view that there is a course of action. There's a course of action, there is a disputed questions of fact. Therefore, summarily, I cannot dismiss somebody because on the face, when you yourself is also admitting that some amount has come to you. So therefore, what is important here and what is important for the court below to see also, when did the course of action accrues? And the court has rightly said, the course of action accrues in the year 2019 when you fail to acknowledge. So, my lord, loan transactions are continuous and composite. They have admitted there was a various transactions therefore there's a cumulative of transactions, my lord, which they have. So therefore, my lord, the court below has rightly rejected the applications under Order 7 Rule 11. And as it is, my lord, they have already filed their written statement also. And if I'm just going through the list of dates that I've given, my lord, I filed the money suit in the year 24th of January 2020.
Yes.
And they have filed their application under Order 7 on 17th February 2020. Then why was the requirement for them to file in the month of July the written statement? So this itself shows that they are in fact not very sure which way to go. The moment you file after your Order 7 Rule 11, you file your written statement, means you are subjecting yourself to the trial on merit and not merely dismissal on law. So therefore, I humbly pray, my Lord, let this the order be upheld and send it back for trial, my Lord. That is all.
My Lord, I have few points and few judgments to submit to my Lord. My Lord.
You want to reply?
Yes, my Lord.
I think we'll have to continue on next date.
My Lord, only on one aspect, my Lord, kindly hear me. This aspect where my learned senior has stated that the presiding officer has rightly decided the application on 7/11. But my Lord, one point, my Lord, has to be clarified that the appellate court, my Lord, district council did not answer to the order of the presiding officer. In fact, had turned over and said that Limitation Act is not even applicable. That aspect is there, my Lord. And my Lord, when it comes to a cause of action is a bundle of facts, my Lord. And it has to be stated in each and every, in its pleading itself. They cannot specifically choose one paragraph and insert a cause of action there, my Lord. That is called a clever drafting. And if that is the case, my Lord, the suit is liable to be dismissed. And my Lord, I have the judgment, my Lord. My Lord, first I'll submit to my Lord this Ashok Kumar judgment. Ashok Kumar judgment. Wait, Master, I think I have extra. Ashok Kumar judgment. So, my Lord, para number, page, internal page number 4 of para 2, my Lord. From Delhi, I think. My Lord, I'll just read.
Para 2?
Yes, para 2 and just the relevant portion, my Lord. After 1, 2, 3, 4. Line number 4. In the law of limitation period for recovery of loan.
Para 2?
Para 2, my Lord. Sub para 2 of para 5. In law, my Lord.
You are saying para 2, now you are saying sub para 2.
My Lord, para 5 of sub para 2. Page number 4, my Lord. Internal page number 4 of page 6.
Yes.
My Lord, I'll just read the relevant part. In the law of limitation, that is from 4th line, in the law of limitation, period of recovery of loan, which is payable on the specific date, then the limitation period commences from the date from which the loan is payable. Limitation in such a case does not commence from the date of grant of loan. Article 19 of the Limitation Act, which is relied upon by the appellant defendant, deals with the situation when there is no date fixed for repayment of loan. My Lord, like in my case, when there is no date fixed for repayment of loan, the appellant defendant therefore cannot place reliance on the Article 19. What would actually apply in the facts of this case? Article 113, and which provides the limitation of 3 years commence from the date of rising of the cause of action. It is when the cause of action arises, then the limitation of 3 years starts from the loan to be repayable. My Lord, I strictly rely on this paragraph, my Lord, wherein it's stated that Article 19 of the Limitation Act, my Lord, will deal when there is no date fixed for repayment of loan. And secondly, my Lord, the judgment of the Dahiban, my Lord. Page number 17, para 13, my Lord. Page number 17, para 13. Page number 17, my Lord, para 13. Cause of action means every facts which would be necessary for the plaintiff to prove. My Lord, is in that page, page yes. 17, my Lord, para 13.
Yes.
Cause of action means every fact which would be necessary for the plaintiff to prove. If transverse, in order to support his right to judgment, it consists of a bundle of material facts which are necessary for the plaintiff to prove in order to entitle to the relief claim in the suit. In so and so versus so and so, this court has held that a cause of action thus means every fact which, if transverse, it would be necessary for the plaintiff to prove and order to support his right to a judgment of the court. In other words, it is a bundle of facts which, taken with the law applicable to them, give the plaintiff a right to relief against the defendant. It must include some act done by the defendant, since in the absence of such an act, no cause of action can possibly occur. It is not limited to the actual infringement of rights suit, but includes all the material fact on which it is founded. In so and so versus so and so, this court held that while considering an application under Order 7 Rule 11, what is required to be decided is whether the plaintiff disclosed the real cause of action or something purely illusionary in the following words. The learned so and so must remember that if on a meaningful, not formal, reading of the plain, it is manifest that the vexation and meritless incense, if not disclosing a clear right to suit, he should exercise his power under Order 7 Rule 11, taking care to see that the ground mentioned herein is fulfilled, and if clever drafting creates an illusionary cause of action, nip in its bud at the first hearing. Subsequently, in so and so versus so and so, this court has held that the law alone cannot permit clever drafting which creates illusionary cause of action.
You're going back to the merits again.
My lord, the cause of action, my lord, is under Order 7 Rule 11 itself, my lord. So my learned senior has stated that, my lord, the cause of action is there. But, my lord, the cause of action on meaningful reading, it's only in para number 18 of the plain. They have never, because cause of action is a bundle of facts, my lord. It has to be reiterated in each and every pleading. That has not been done, my lord. And, my lord, specifically, if I can say, my lord, the application which is barred, my lord, barred by law, barred by the law of limitation, my lord, it is clear, my lord, from reading the plain itself. And moreover, my lord, the learned appellate court had never gone into that aspect of the presiding officer, whether they have decided the application wrongly or rightly. It has never gone into that aspect, but directly came into that aspect that this limitation act is never applicable to the tribes. First, and secondly, my lord, it has clearly stated that in money cases only Article 113 will be applicable, which is a residuary clause, my lord.
I will cite once to reply to all my friends. Just one, my lord, may take down these citations. 2005 7 SCC 510. The party is Popat and 2005 7 SCC 510. That's Popat and Kotecha property, my lord. It's a paragraph 7, paragraph 8, paragraph 9, my lord. Paragraph 9, my lord. Here, my lord, the Honorable Supreme Court has emphasized that Order 7, Rule 11 cannot be invoked where disputed facts requires adjudication. So it says the paragraph 9, it says, rules of limitation are not meant to destroy the rights of parties. Here, admittedly, they have some money transaction has happened. So you cannot take the shelter of Order 7, Rule 11 to destroy my rights. That these citations, my lord, overrides all whatever citations my friend has given just now, my lord.
My lord, I may be allowed to go through the citation of my learned senior, and I will revert back, my lord. Because, my lord, I did not...
Yes.
My lord.
So you'll file your written argument?
Yes, my lord.
My lord.
We'll file.
There are counsel for the parties. Hearing is concluded. On premiere for written argument to be filed. Matter is posted after 2 weeks.
My lords, I may be allowed to revert on the
Yes.
citation.
In your written argument,
Yes.
whatever citation, in fact, you have to also give him your
Citations.
the citation that you have. I mean, the authorities you are relying upon.
Yes.
Obliged, much obliged.
Item number 10.
Yes,
Uh,
I think we have to fix next date for this. So what do you suggest? What is this fixed for?
It is fixed for hearing, Lord.
Hearing.
Okay, not yet heard.
No.
No.
What time is that for it?
Can fix it on Tuesday, Lord.
Tuesday.
Item 14 है this is for filing the course appeal.
Lordship, here item number 10 is fixed for filing a written argument, and analogous matter is item 14.
You are in 10?
I'm in
10,
14.
He is in 14. So 14 it is.
So 10, I think that has been clubbed together with.
Yes, clubbed.
Been
So this
adjourned.
is- okay, now we are in 14 then.
Now we are in 14.
10 घड़ी भर का तो का हुए वो for written argument. So 14, what do we do?
For
When do we hear it?
14, yes, Lordship.
When is this? 10? 1 week then?
Lordship, yes, it may come upon 14, no, 15. If you have any problem, if we can
15.
15. Otherwise,
15.
Otherwise, it can come up after lunch. No, at my friend's.
Any date I'm here, Lordship.
15, madam.
Let it come on 15.
On premium, what is Lizzie's matter? 15.
Much obliged.
15.
Second call, item number 2.
15 is what date?
Yeah, I examined it. I spoke to IO, so we'll have to take some instructions.
Millards, first I think I an apology is due for my end, and Millards, because the instructions that were coming in were a little contradictory from both sides. Now what we've realized, Millards, after running through the entire case records, that in this case there is already an anticipatory bail granted to one of the petitioners, Millards, by the Supreme Court in that warrant matter, and that's recorded by the learned court below. Millards, I'll just place the certified copy. Your Lordship will just see these two orders. Blue flag is by where the NBWA is issued, Millards, and yellow flag is where the court records the Millards, anticipatory bail order passed by the Supreme Court. Have copies of the Supreme Court order. Please go to the court master.
This is the Khanapara PS case.
Yes, Millards.
You in this petition you have come in which case?
Same case, Millards, 25/7. That's why I said an apology is due for my and my instructions were shortcoming. I've asked my learned friend. My learned friend was equally, Millards, not instructed, if I may put it so, by the prosecution. So that's why all this confusion was happening.
But they have come up, so
They
they approach the court.
I have come up.
My lord.
Once it has come to my notice, my first job is to inform your Lordship.
Petition would dismiss as infructuous.
We'll withdraw it, Millards. In view of this, in view of the order dated so and so by the Supreme Court, Millards, I cannot. That's, Millards, in one matter. The other is.
That is in which matter?
Millards, this is AB number 5 of 2006. Kaushalya, Millards, there is no order. Kaushalya is the wife. Kaushalya, she has never been issued. We are simply saying, Millards, Kaushalya will also go and, in view of this anticipatory bail order, other person being on bail, she will also go and appear before the IO. To that limited extent, your Lordships protect me. I will go and appear before the IO.
That naturally you'll have to do. But
Your Lordships can dispose of 5. in view of, my lords, the...
5 years.
That's withdrawn. Yes, my lord.
Withdrawn in view of the order of the Supreme Court, my lords, and recorded by the trial court, that your lordships may record. In so far as, my lords, 4 is concerned, she is not a named accused, my lords, she is only the wife of the prime accused. Your lordships, I had pointed out before, my lords, your lordships have seen that, my lords, the law is now very specific. Your lordships say that all the offences that I'm charged with, my lords, and we had prepared and submitted a chart on the last occasion about the offences. I think it's on record, that chart. No, we prepared. The sections, my lords, are all less than 7 years. I'll take your lordships to the sections, my lords.
Where is the chart?
I don't know, my lords. I'm sorry, my lords, probably in the other matter. I'll just take your lordships to the sections, my lords. First is section 381. Go to the second schedule straight. Section 381, my lords, is theft by clerk or servant, my lords. Imprisonment is for 7 years. Cognizable, non-bailable. Then, my lords, second is 408. 408, as your lordships are aware, is a criminal breach of trust by clerk or servant. Again, 7 years, non-bailable, cognizable. Then, as well as 120B is common intention, as your lordships are aware. Then 417 is cheating, my lords, 1 year. Then 418, my lords, is again 3 years. 420 is, my lords, 7 years, up to 7 years. 465 is, my lords, 2 years. 468 is, my lords, 7 years. 471 is again, my lords, forgery of the documents, so it will be 7 years again, my lords, to be calculated. 201, 419, my lords, I'll just point out. 419 is 3 years. 201 will be again, my lords, and 397 and 34.
So whatever the case, all these offences...
All are below 7 years.
All are below.
Below 7 years. So, my lords, therefore, under the new mandate of law, which your lordships have also recorded in that earlier judgment delivered by my lords, my lords, mandatory notice under 35 has to be issued to the...
Which was not done.
Which has not been done. I am saying, my lords, that I want to come and appear before the prosecution. Your lordships will further consider, my lords, that the Supreme Court has already granted the other petitioner bail, my lords.
So, we are seeking bail on 2 counts.
My lords.
Number 1 is because all
less than 7 years.
Offences are less than 7 years.
My lords.
And the other is parity.
My lords. And, my lords, saying that to prove our bona fides, your lordships may fix a date.
Well, that is...
We will go and surrender.
That goes without saying.
My lords. No, even if your lordships may not be inclined to dispose of the matter at this stage, my lords, I am only saying this, that your lordships may want to say that, okay, you go and appear on so-and-so, we'll protect you limitedly, you go and appear, and then we'll consider the matter. That also we are willing to do.
Lordship, what has been prayed is for bail to the extent that they'll appear before the concerned IO, my lord. But thereafter, my lord, whatever transpires will not be, the same protection will not be granted, because there's a lot of documentary evidence against the accused person over here also. The transaction, as we have given before this honorable court, we have placed before this honorable court, a lot of transactions have flowed from what has happened in Shillong to their private companies.
Those are matters of, firstly, evidence, investigation.
Relevant paragraph.
And secondly, they are matter of evidence before the court. What is the stage of the case?
Because there are certain documents yet to be recovered. We have only...
Investigation not completed.
Investigation is not complete, my lord. It's ongoing because many documents...
Charge sheet not filed.
Charge sheet not filed because many documents are in the possession of the accused in the other case, my lord.
Whatever.
And also the second accused.
If the accused has undertaken to cooperate with the IO, then the IO will do his job. If there's non-cooperation, then that would be a violation of the bail condition.
My lord.
For the parties, I'll pass the orders.
Obliged.
Much obliged, lordship.
That Satinder Kumar Antil's judgment, whether your lordship should... That 7 years, my lords. Your lordships have already referred. We have a copy for your lordships. Ready reference. We'll just place it.
And for me?
Highly obliged.
Much obliged, lordship.